Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about why you shouldn't put a forced sale provision of your homestead in your Florida will. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so sometimes this issue comes up when I'm presented with a will. Many times this will was done via the internet or by a practitioner who may only dabble in wills, and estate planning is not their primary practice area. And the will say that the personal representative is instructed to sell the homestead and divide the proceeds of the sale amongst the heirs or the beneficiaries, usually their adult children. And the goal of somebody making that request in their will or putting that proviso in their will is to attempt to avoid bickering amongst their children after their death, to just basically, make it clear that they want the family home sold and that they want their adult children to, or their beneficiaries to just share in the proceeds. The problem with putting such a provision in your will is that it now makes your homestead no longer exempt from creditors. So the homestead protection under the Florida Constitution would otherwise protect that property from creditors that might present in the homestead proceeding. But if the will directs that the homestead property be sold, that creditor protection is now lost, and the creditors are able to be paid from the sale proceeds before the distribution of those proceeds to the beneficiaries. Had the will been silent on whether or not the homestead should be sold, the personal representative could have petitioned for homestead protection, had the homestead transferred into the names of the beneficiaries, and at that time then the beneficiaries could list the property for sale and divvy up the proceeds equally without having to pay anything to any creditors that appeared in the probate. So that's why many times estate planning attorneys might advise against putting such a proviso in a will. You can still make your wishes known to your beneficiaries during your lifetime, that that they are welcome to sell the property, that there's no need to hold on to the family home as some sort of legacy. But once you put that mandate in your will, you do lose protections that are otherwise available for homestead property under the Florida Constitution. If you want to learn more about this topic or others, feel free to schedule a free strategy session with me at eldermeeting.com. Otherwise, I thank you for joining me. Have a good one.